What would I do without you? Good morning, everyone. I'm Judge DeLuca. Welcome to Broward County Magistrates Court. State, please state your, in the courtroom, please state your appearance.
Eric Linder on behalf of the state, Your Honor.
And for the defense?
Brian Reedy from the Public Defender's Office.
And do we have an attorney from the Public Defender's Office at the main jail?
I'm quite certain that we do. Is it Mr. Romero over there? Is Mr. Romero over there?
Is there a mic on?
Yes, well, we'll have him show up.
Mr. Romero, are you at the main jail helping us out?
Yeah.
I can't, Mr. Romero, I can't hear you. Is your mic,
Announce your presence for the record, Mr. Romero.
Mr. Romero? I don't know that he's hearing us.
Yeah, got it. Yeah. Does he have a first name? Does he have a phone number? Okay. All right, bye.
They don't see or hear anything?
You want to turn it off and turn it back on?
Okay. Mr. Romero, can you hear us now?
Good morning, Judge. Yes, I can.
Okay, we're up and running.
Okay. No problem, Judge.
And Mr. Romero, was the tape played this morning as far as notification of rights?
I have no idea. Let me ask the deputies. Oh, was the recorded message as far as informing the in-custody clients as far as their rights and everything like that? Yep, they're telling me it runs every morning.
Okay, thank you, sir. Okay, again, good morning, everyone. I'm Judge DeLuca. Welcome to Broward County Magistrates Court. I'm going to take a moment just to go through some of the rights that you need to make sure that you are aware of. These are criminal proceedings. Each of these cases allows for a period of incarceration if ultimately at trial there is a plea of guilty or no contest or a finding of guilt after a determination of disputed facts. Today is not the day to dispute the facts. The limited role of today's purpose is for a determination of probable cause based upon the sworn affidavits that have been provided to us. Everything that you say is being recorded, and it is usually in your best interest not to discuss the facts of your case because it can be used against you in any subsequent or future proceedings. Once there's a determination, if there is a determination of probable cause, then the issue is what is the custodial status, whether there will be a bond amount or some sort of pretrial release or custodial non-bond on the particular matter. The state attorney is here in the courtroom. The representative for an attorney from the public defender, Mr. Reedy, is here in the courtroom as well. And over there at the main jail is Mr. Romero. For the purpose of this morning's proceedings, the Office of the Public Defender will be representing everybody unless there's private counsel retained. And when your case is called, if you have a private attorney and you're expecting them to come, let me know. We'll put your case to the end of the docket. If they're still not here, then at that point we'll try and reach out and see if what their scheduling is and how we can accommodate you. Again, these are criminal proceedings. I will admonish you if you start to discuss the facts of your case. If you defy the admonition of the court, you're certainly welcome to say whatever you want, and I'm sure the state attorney will thank you at some point during a future proceeding. Everybody ready to proceed?
Yes, Your Honor.
Okay. Madeline St. Charles.
North Broward.
Good morning.
Good morning.
Good morning, Ms. St. Charles. You have an out-of-state hold on a felony capias. I do find probable cause. Bond is set at no bond. Have a good day, ma'am.
All righty, you too.
Jesse Johnson. Is it okay if I just send them down to you? Okay. Okay.
Mr. Johnson's here at main, Judge.
Mr. Johnson, you have an out-of-state hold on a felony. I do find probable cause. Bond is set at no bond. Have a good day, sir. Okay. Sarah Fuller.
Good morning.
Good morning, Ms. Fuller. You have a new substantive charge for a misdemeanor battery. I do find probable cause. Bond is set in the amount of $1,000. Have a good day, ma'am.
Judge, I'm
Yes, sir.
going to be asking the court to consider placing Ms. Feller.
Miss
Yeah.
Fuller, don't go away yet.
I'm going to be asking the court to consider placing her on pretrial release. She's not going to be able to make a $1,000 bond. I would also ask that as a condition of pretrial release, there be mandatory drug testing. I've had a conversation with her father this morning. He's a little worried about her. Wants to make sure that if she is released, that she's behaving herself. As the court can see from reading the probable cause affidavit, this took place at a detox facility. And she can't go back to that facility, but she does have some friends that she can stay with. I left a message for one of them, and I'm hoping to hear back from him shortly. The bottom line, Judge, is she's not going to be able to make a $1,000 bond. So she can either sit in jail, or if the court considers allowing her to be released on pretrial release with mandatory drug testing, that's what I'd be asking the court to do this morning.
Mr. Linder?
Your Honor, well, first off, in addition to any bond or release conditions the court deems appropriate, I'm going to be asking for an order of no victim contact.
That's fine.
In addition to that, I do believe that Ms. Feller can post a bond because she's currently out on $11,000 worth of bond out of Dade County on open charges of burglary of a dwelling, criminal mischief, grand theft auto, grand theft of a firearm, and preventing or obstructing a fire extinguishing equipment.
That is correct, Judge, and she has a court date coming up on Thursday of this week in Dade County for those charges. But the person who posted that $11,000 bond is not posting this $1,000 bond, and she can't do it herself.
I want to thank the lawyers for their respective input. Bond will remain at $1,000. Have a good day, ma'am.
Thank you, Judge. All right, I'll call your dad, okay?
Kimberly Meyer,
Medical research, Your Honor.
medical reset. Yeah, roll it over till tomorrow, please. Counsel, Emily Elise Bex.
She's here present, Judge. She has private counsel, Mr. Jonathan Marr. Oh, there he is. There's your attorney. Come on in, man.
Morning. Good morning, Your Honor. I'd be arguing, well, I don't know if you had the opportunity to review the
Yes,
probable
sir.
cause affidavit. I'd be arguing this is a trespass, Your Honor. You have somebody who's, I know the state's can argue stealthy entrance, but right in the first line of this, it says that via surveillance cameras, the defendants were seen entering the site. So I don't know how it could be a stealthy entry other than it's at night and she's a trespasser. Further down, if you continue reading, there's a male suspect who confesses to everything, confesses to owning the book bag, to spray painting the building. Ms. Bex was only a trespasser at best.
Mr. Linder?
Thank you, Your Honor. Well, my first argument would be under the jury instructions and definitions in burglary. The state can establish intent to commit a crime through circumstantial evidence, Your Honor. And certainly her presence with another individual that was there committing a crime, I would argue the circumstantial evidence of probable cause. Secondly, if the court does not accept that argument, yes, it is true that intent to commit a crime can be proven by stealthy entry. Counsel mentions the surveillance video. That was used by off-site security. Even the security officer that was present on scene had no idea that Ms. Bex and the defendants had entered the property. They weren't aware of that.
Mr. Linder, can you hold on one second?
Certainly, Judge.
Do we have any idea where this extra background noise is coming from? I'm sorry, ma'am?
She can hear us still.
That's coming from the main jail?
Mike picks up everything.
All of this new, beautiful equipment and the mics? We don't have noise-canceling microphones over at the jail?
Apparently not.
Has that caused a problem with allowing for the accurate recording of these proceedings? I mean, I have excellent lawyers making arguments to create a record, and it's a shame if that's not being properly recorded.
Truthfully, I don't know if it affects the recording per se. I do know, I can tell you, it makes things sometimes difficult in here. Just communicating to the court and for the defendants to hear us.
Well, thank you, Main Jail, for killing the mic and helping us out. Yes, Mr. Linder, proceed.
Thank you, Your Honor. What I was saying is the on-site security officer wasn't even aware that Ms. Beckson and her co-defendants had entered the property. It was only after an offsite security company who had access to the surveillance notified him was he able to alert the authorities. Also noting the time of the entry, this was in the middle of the night. Ms. Beckson and her co-defendants were arrested a little after 4:30 in the morning. So this wasn't an entry onto this property in the open of the sunlight, Your Honor.
If I may briefly respond, Your Honor.
Yes, sir, of course.
Under State versus Martirall, knowledge and even presence during the commission of a crime does not make you a co-conspirator, okay? Just because she's present, just because there's another defendant spray painting, does not mean that Ms. Bex is aiding or furthering or a co-conspirator. And just because a security guard who might just be sleeping on the job doesn't see people enter, doesn't mean they don't enter right through the front gate. The security cameras picked up Ms. Bex and the other defendants. One of the defendants confessed to the crime. Why should the other three be charged just because of their presence? And presence and knowledge under State versus Martirall does not equate co-conspirator. This defendant does nothing in furtherance but be present, according to probable cause affidavit. And as far as stealthy entry and circumstantial evidence, she's a trespasser.
Your Honor, Mr. Martin can't defeat an argument of stealthy entry by just saying she's just a trespasser. That has nothing. That is not a response to whether the entry was stealthy. And as far as his argument that the security guard was sleeping, that's mere speculation.
All right, I'd say it's mere speculation by the state that this is stealthy entry. The security cameras, first line, in reference to subjects observed via surveillance cameras entering the construction site. Just because somebody enters something in the dark or at night doesn't make it a stealthy entrance. Stealthy entrance is hiding behind a tree and climbing through a window of an apartment. A stealthy entrance is hiding you're entering the premises. Nowhere in any of this probable cause affidavit does it say that, but what it does clearly state is that one of the male defendants took responsibility for all of the criminal actions except for the trespassing of the others.
Your Honor, a video camera catching someone entering doesn't make it any less stealthy. Many people put cameras in their homes now. That doesn't make the person's actions less stealthy. It just means they're getting caught by a camera, but not necessarily by the individual that's home or the security guard in this case.
There are no facts that establish a stealthy entry here other than it happened at night. The cameras saw it, the security guard didn't. That doesn't mean he wasn't walking around the area. That doesn't mean he wasn't sleeping in his car. The local security guard, who may very well be just sitting in a vehicle, awaiting an off-site response, which is what they got, saying that 4 subjects were seen plainly on the security camera walking into the construction site. That doesn't make stealthy entry. The hour that it happens doesn't make stealthy entry. Ms. Bex is a trespasser. And how could we say that she isn't when the other co-defendant said the book bag's mine, the spray painting's mine, and I did that? She's a trespasser.
Doesn't the time of the entry factor into this at all? Of course it does. And doesn't the fact that the allegations are that they went there armed or in possession of spray paint would allow for the entry with the intent to commit vandalism? It does. I understand.
If I may briefly respond, Your Honor?
Sure, of course.
One of the defendants had that inside a backpack. There's nothing to state that Ms. Bex had any knowledge of what the other defendant is going to do once they're there. She's there. She trespassed onto the site. That appears clear to me. But to say that she's a burglar because she's with somebody who spray painted without more facts, I think we're taking too much of a leap. Right now, all we have is Ms. Bex as a trespasser. If once it hits the trial court, they can produce more facts and upfile it, that's fine. But we have a college student here who will be greatly prejudiced by this quantum leap, okay, to say that, oh, because she walked onto a construction site in the middle of the night with some idiot who she may not very well have known, because there's no facts to establish that she had any knowledge of what the other defendant was going to do, or that she was even present while he did it, other than the 4 of them walk out and surrender themselves. Hey, we're here, no trouble. The one defendant who committed the burglary, arguably, said, I did this, that's my backpack, I spray painted this. He didn't say, and Miss Bex knew about it, and they knew about it, and they were here with me, and we all came to do this. There's no facts to that, none whatsoever. The facts of this probable cause affidavit establish Miss Bex was a trespasser in the middle of the night. Not that she committed any underlying felony, not that there's circumstantial evidence to demonstrate that she intended to commit or that she acknowledged that a third party was committing. She's a trespasser, Your Honor.
Counsel, I understand your eloquent arguments. I do find probable cause. Any priors?
Your Honor, I don't see any. What I'm going to request is that Judge Schiff had her 3 co-defendants yesterday afternoon. He set a $1,000 bond on each co-defendant with an order not to return to this property. I'd be requesting that the court set the same bond for her that he did for her co-defendants.
Vince?
No objection to that, Your Honor. $1,000 is a reasonable bond. We object to the charge.
Ms. Bex, I just want to point out your lawyer's been here bright and early this morning protecting your interests in this matter. I do find, having found probable cause, I do find $1,000 is a reasonable bond. Anything else?
No, thank you, Your Honor. Ms. Bex, don't speak to anybody about the facts of your case. You'll be out quickly.
Have a good day, ma'am. Okay. Marion Guadalupe Hibbard.
Miss Hibbard is here at main judge, and she is approaching. Come on up, ma'am.
Good morning, Ms. Hibbard. You have a new substantive charge of criminal mischief. I do find probable cause. Bond is set at $500. Have a good day, ma'am.
Judge, if I may be heard.
I'm sorry?
If I'm...
Okay, we're being advised that the bond has already been posted.
Oh, okay. Thank you.
Thank you for the updated information. Sean Lundstead?
No, bro.
Yes.
Ms. Lundstead, you have a new substantive charge of grand theft. I do find probable cause. Bond is set in the amount of $1,000. Have a good day, ma'am.
Judge, I'm going to be asking the court to consider pretrial release for Ms. Lumstead. She's been living here in Florida all of her life. She's been living in the same location for the last 2 years. I think that she does have some prior contact with the criminal justice system, but I think it's like 5 years ago for some type of narcotics charge. She does have family who live in Port St. Lucie, so she has ties to the community. She has a stable residence, and I'd ask the court to consider releasing her to pretrial release because she is not going to be able to post a $1,000 bond.
I'm showing a DUI from 2012. I have no objection to
Pretrial?
Pretrial, Your Honor. I would just request an order of no return to this particular target, please.
That's fine.
Pre-trial, have you had the opportunity to verify?
We have not spoken to her nor made any verification. The court orders us to carry out the parent order.
Well, I discussed this with Ms. Lundstedt earlier, and I advised her that she will be required to report to pretrial release within 24 hours of getting out of jail. If she gets out of jail in time today to get here, then she should do it today. If not, certainly early tomorrow morning, first thing. So she's aware of her responsibility. The deputy at the jail is going to give her a map so she knows where to go to check in with pretrial release either late this afternoon or tomorrow.
I'm showing 2 different addresses. On the booking report, I'm showing a Deerfield Beach permanent address, indicates 24 months. And then on the probable cause affidavit, I'm showing a permanent address of in Port St. Lucie.
Yeah, I think that's her parents' address in Port St. Lucie, Judge. What's your address, Miss Lundstedt?
It's 110 Northeast 19th Avenue.
Is that apartment 12A in Deerfield?
Yeah.
And how long have you been living there?
2 years.
Is that where you're going to go if you're released?
I'm sorry?
Lundstedt, is that where you're going to go if you're released?
Yeah.
You don't seem real committed to that.
That wasn't very
Ms.
convincing.
I have
Lundstedt.
to advise the court of this. Having just mid-February, Ms. Lundstedt updated her mailing address and residence with the Florida Department of Highway Safety Motor Vehicles to the Mediterranean Boulevard address in Port St. Lucie.
Yeah. I'm actually kind of homeless the last 2 weeks, so to be honest.
Pre-trial?
In your eyes, it's really up to the court, even though she's homeless. It's more difficult,
Yeah, it's
of
gonna,
course, for us to supervise her, as we can't always be able to reach out to her, but if the court orders us, then.
Well, is this just setting it up for a failure, or is this something that, I mean, I'm considering it, but I don't wanna create a failure that's not in Ms. Lundsted's best interest either.
There are some judges who do that, and we never see the defendant until they get rearrested.
Okay.
And then other times they're released and some actually do show up.
In consideration of all of the information before the court, pretrial release is declined, bond will remain at $1,000. Have a good day, ma'am. Okay. Erica Parks?
Judge Bond also.
I'm sorry? Bonded? Thank you. Technavian Ashley?
Ashley is here at Maine. She's approaching. Come on up, ma'am.
Ms. Ashley, you have 2 new substantive charges, grand theft auto and driving while license suspended, third or subsequent offense. I do find probable cause as to each.
Judge, can we check to see if her bond's been posted?
Has not been posted as of yet. Bond is $1,000, count 1, $750, count 2. Have a good day,
Thank you.
ma'am.
I'll call Jesse right after court, ma'am.
Esme Maldonado.
Hold on, Your Honor.
Good morning.
Hey, Your Honor.
Good morning, Ms. Maldonado. You have new substantive offenses for DUI. You have a probation violation, careless driving, and speeding, which are both the traffic what is count 4?
I've never seen that before, Your Honor. I guess it's a third speeding. If I can have one moment, I'm gonna check the statute. Okay, so basically, under Florida statute, if a person exceeds the speed limit by 50 miles per hour or more, a third time, they can be charged with a felony. I suspect this is a misbook, because it doesn't specifically mention how fast she was going over the speed limit. I suspect she might have received a citation for speeding, and that was the officer's intent, but he put in the wrong statute number.
I'm going to ask for an ROR on that count.
I'm not even going to ask the court to find probable cause on that count.
Okay, that's fine, too.
So the court finds probable cause as to counts 1, 2, and 3. No probable cause as to count 4. No time to perfect. ROR is set on that count. Bond is $500 on count 1. No bond as to count 2. Do we know when do we have a date for the probation violation coming up in court? I'm sorry?
It's out of Port St. Lucie.
That's in Port St. Lucie. If the probation violation was here in Broward County, I'd be able to give you a court date, but since it's in Port St. Lucie, they will be in contact with our folks here. I cannot give you any additional information, so I apologize for that. But the bond on the local charges is the bond is set only on count 1, $500. I issued an ROR as to count 4. Have a good day, Ms.
Consider
Maldonado.
RORing Ms. Maldonado on count 1 so that Port St. Lucie can come and get her.
Your Honor, I would ask that the court keep the bond in place. It's a DUI. It is somewhat related to the charge that she's on probation for, which is controlled substances.
Bond will remain $500 on count 1. Have a good day, ma'am.
Good luck, Ms. Maldonado.
Thank you, Your Honor.
Hans Joachim Collins. Mr. Collins, you have a capias.
Judge, this Munis warning.
Yes, sir.
I know the state doesn't represent the city and the defense doesn't represent the defendant, but anybody have a suggestion?
It's kind of up to Mr. Collins if he wants to resolve the matter or not.
Mr. Collins, do you have a residence address?
Yes, sir.
Is that in Hollywood?
Yes, sir.
If I release you ROR, will you show up for court?
Yes, sir, I will, sir.
I do find probable cause on the capias. I'm going to issue an ROR. Have a good day, sir.
Thank you, Your Honor.
John Green.
He's here, Sergeant Judge, I'm Maine.
Mr. Green, you do have a capias on a misdemeanor. I do find probable cause.
Judge, in speaking Mr. Green, he wishes for me to ask the court if the court would be inclined to resolving this matter today. I don't know if the state has a plea offer for Mr. Green.
State, do you have an offer?
One moment, Your Honor.
Take your time, Mr. Linder.
Thank you, sir. Your Honor, the best offer I can make him today would be an adjudication, 10 days in county jail. My notes from the prosecutor handling this case in Judge Hurley's division is that Mr. Green is a habitual trespassing offender. I'm showing in addition to this case, he has 4 pending trespasses in front of Judge Hurley. Last year, I'm showing 1, 2, 3. So far, about 9 trespasses last year, and I haven't counted all of them. And this alleged trespass was at the Abco food store at 56 Northwest Eller Street in Deerfield. The arresting officer advised he's been trespassing this location numerous times.
Judge, I don't know if I heard correctly. Does Mr. Green have current open trespass offenses?
About four others.
State indicates possibly 4 others.
If there are misdemeanor offenses, Judge, I don't know if the court would be inclined maybe resetting them for this afternoon so that maybe we could try and see if we can get their case numbers and see if the court's willing to resolve all 4 pending matters.
Do we have that ability?
I know it's been done in the past, but I don't know what's the mechanism for it. And then he would probably be interested in accepting the state's offer of 10 days.
Mr. Romero, let's set this over to the afternoon, and I don't know if you're going to be able to get the information, but if we are, we'll take a look at it.
I'll provide Mr. Reedy with the other case numbers.
Okay.
Thank you.
At this time, I do find probable cause. Bond is set at $1,000. We're going to readdress the matter on the afternoon docket.
Thank you, Judge.
Thank you, Mr. Romero. Thank you, Mr. Linder. Freddie Kornblith.
Mr. Kornblith is here present at Maine Judge Municipal Ordinance case.
You live alone with someone different.
Mr. Kornblith, this is a municipal ordinance violation. You do have a capias. I do find probable cause.
Mental problems?
Do you have any felony cases pending, sir?
No.
Do you have any other cases pending, whether they're felony or misdemeanor or municipal ordinances?
Your Honor.
I'm sorry?
No, Your Honor.
Are you on probation for anything?
No, Your Honor.
Are you interested in resolving this case?
Yes, sir.
Now, either way, even if you do not enter a plea on this case today, I'm going to change your release to an ROR. So you're getting out. I don't want you to feel that you have to enter a plea so that you can get out of jail today. Do you understand that?
Yes, sir.
Are you still interested in resolving the underlying alcoholic beverage case?
Yes, I would just like to plead no contest.
Okay, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
Okay, I accept the plea, adjudicate guilty, time served, and court costs, 6 months in which to pay. Is that acceptable to you, Mr. Kornblith?
Yes, Your Honor.
Have a good day, sir.
You all, sir.
Okay. Marcos Gonzalez.
I've been advised he bonded, Judge.
Thank you, sir. Gary Altman.
Mr. Altman, come on up, sir. Munis Foreign.
Mr. Altman, you're charged with a municipal ordinance violation of soliciting motorists. I do find probable cause. Do you have any other cases pending anywhere under any name? Okay. Are you on probation for anything?
No.
Okay. Your choices are, if you enter a plea of no contest, I'll adjudicate time served, impose court costs, or I'll issue an ROR, so either way you'll be getting out today. What would you like to do, Mr. Altman?
No contest.
Okay. Fine. I accept the plea. I find probable cause. I find a factual basis. Adjudicate guilty. Time served. Court costs, 6 months in which to pay. Is that acceptable to you, Mr. Altman?
Yes, sir.
Have a good day, sir. Okay. Nikki Richard.
Mr. Richard, come on up, please.
Mr. Richard, you have a new substantive charge for battery. I do find probable cause. State priors?
I'm showing 32 prior misdemeanor convictions and 17 prior felony convictions.
Okay, bond will be set at $1,000. Have a good day, sir. Okay. Michael Toros.
He bonded, Judge.
Thank you, sir. Nicholas Massa.
North Broward, I believe.
He's a medical reset, Your Honor.
Thank you, sir. Marvin De La Rosa.
He's here present, Judge, at Maine. He declined the service as a public defender.
Good morning, Mr. De La Rosa. How are you today?
Morning. Good morning.
You're declining the services of an attorney from the Public Defender's Office for this morning?
Yeah.
Okay. Are you going to be retaining private counsel?
Yeah. I understand.
Okay. The question is, you're declining the services of an attorney.
Yeah, I have an attorney.
Who is your attorney, sir?
Arturo, I just don't know his last name that good. Arturo Takata or something.
Are you expecting your attorney to be here this morning?
I haven't got any contact with him.
Okay. These are ad charges. I do find probable cause as to each.
Yeah. Okay.
State, is a bond supposed to be set on count 5?
Your Honor, I'm not going to be seeking a no bond on counts 5 and 8. I am going to
This fucking process,
I'm going to be requesting 15,000. They are punishable by life offenses. On 5 and 8, I'm going to be seeking $15,000 bonds each, based on the nature of the allegations, the amount of damage that was allegedly done to the vessels. I would note, Your Honor, among his first 4 charges that he's already being held on, one of which is a burglary involving the same type of allegations. His bond was set over the weekend at $7,500 on that charge, and I'm just checking to see if there's any history right now.
So as to what's appearing on our docket today as count 5, you're recommending a $15,000 bond. On count 8, $15,000 bond?
Yes, and on count 6, Your Honor, a $7,500 bond, which would be the same bond that was set by, I believe it was Judge Lee over the weekend on a burglary conveyance.
Having found probable cause, bond is set at $15,000 on our count 5, $7,500 count 6, $1,000 count 7, $15,000 count 8,
And I'm sorry, I'd also request $7,500 on 9.
$7,500 on count 9, and $1,000 on count 10. Have a good day, Mr. De La Rosa. Alberto Gomez.
He's approaching, Judge. He's here in Maine.
Good morning, Mr. Gomez. You have a new substantive charge of grand theft at Home Depot. I do find probable cause. State priors?
Mr. Gomez was placed on pretrial supervision on the 8th of January in case number 19369 CF10A. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked at this time.
Your Honor, in addition to his pending grand theft, he has priors for possession of heroin 2017, grand theft 2015, heroin 2014, theft 2014, felony theft 2014, theft and battery 2013. Goes on from there, Judge.
Judge, what I'm going to be asking the court to consider is, rather than revoking his pretrial release and holding him no bond, which is the most severe sanction this court can impose, I'd ask the court to consider something less extreme. Consider releasing Mr. Gomez on a heightened form of supervision rather than standard on level 2 with the monitor. The new law offense that he picked up is nonviolent in nature. Right now, he's basically financially indigent. He's currently looking for work. He does side jobs. The good thing is he resides in Hollywood, and the owner of the premises allows him to live there basically rent-free so long as he helps out as far as cleaning the property. So he does have a place to stay. So I'd ask the court to consider level 2 pretrial on the case that he's currently out on this new law offense.
Thank you, Mr. Romero. In consideration of the facts before the court revokes pretrial release in 19-00369 CF10A and imposes no bond on that said account. On the current new substantive charge, the court sets bond at $10,000. Have a good day, sir. Tyrus Gordon.
Hey, Mr. Gordon is approaching, Judge.
Mr. Gordon, you have a new substantive charge for possession of cannabis within 1,000 feet of what is this?
It's a convenience business.
I do find probable cause. State priors?
As far as Broward, a misdemeanor possession of cannabis in 2016. Just checking to see if I have anything else. No other adult priors, Judge.
But you're limited to Broward County, correct?
No, I have.
Oh, you have everything?
The only thing I'm asking the court to consider is considering his lack of significant criminal history. I don't know if the court would be inclined for a bond reduction from $5,000 to $1,000. If the court's not inclined, Judge, I'd ask the court not to take any action. I did get the phone number of his family, who I intend on calling after court.
State care to be heard?
No, Judge.
Upon the facts of the case as alleged in the probable cause affidavit and the facts before the court, I accept Mr. Romero's recommendation. Bond is set at $1,000. Have a good day, sir.
Judge.
Okay. Brandon Hinnick.
Was this case taken off the docket?
That's what I was informed, Judge.
Thank you. Willie Johnson.
Mr. Johnson, come on up, sir.
Mr. Johnson, you have a new substantive charge for trespassing. I do find probable cause. And you also have a violation of probation under 16-002411 CF10A. Bond is set at $25, count 1, no bond on the violation, and the court date is on the March 13th at 8:30 a.m. Have a good day, sir. Okay. Reginald Foster.
Yeah. Mr. Foster is here, present at Maine, Judge. Come on up, sir.
You on pretrial?
Mr. Foster, you have a two new substantive charges: burglary, unoccupied, and grand theft. I do find probable cause as to each. State have a recommendation for the bond on count 1, and are there any priors?
Yes, Your Honor. I'm gonna be requesting a $5,000 bond on count one. He does have criminal history out of Broward County, 2014. Two separate possessions of cocaine. One was the possession of cocaine, possession of PVP, another possession of cocaine, sentenced to just under 40 and a half months state prison.
Thank you, sir. Defense care to be heard?
Judge, the only thing I can let the court know is unfortunately he's homeless, he's financially indigent. There's nobody that's going to be able to afford his monetary bond, so I'd ask you to take that into consideration, determining reasonable release conditions for Mr. Foster.
Thank you, Mr. Linder. Thank you, Mr. Romero. Bond is set at 5,000, count one, 1,000, count two. Have a good day, Mr. Foster. Eric Salvin.
Mr. Salvin is approaching. He informed us he has private counsel, Judge Adam Harmelin.
Good morning, Mr. Salvin. Are you expecting your attorney to be here this morning?
I believe my wife got in contact with him last night, so I don't know. I know he has an office across the street from the courthouse. So.
I tried to reach the judge, but based on the spelling of the name that I was given, I couldn't find an attorney by that name, so I couldn't call him.
Mr. Reedy tried to, as an accommodation, to contact your attorney and was unable successful to do so. This is a warrant on a felony battery. I do find probable cause. Bond is set at $1,000. If your lawyer appears before the session is complete, we'll call the matter back before us. Have a good day, sir.
Your Honor, in an abundance of caution, sir, one moment. I'll be asking for an order of no victim contact with Haywood Mathis.
And no victim contact. Have a good day, sir.
Yes, sir. Thank you.
Jean Rudy Thermidor.
He bonded, Judge.
Bonded, thank you. Timothy Ryan.
Mr. Ryan, come on up, please. Judge, he declined to serve as a public defender.
Your Honor, I have regional counsel on this, and I missed a court date in Judge Weeks' courtroom because I was in the hospital having heart surgery. And when I went to court the third day after my court date, my attorney wasn't there. I called his office repeated times. I spoke to my judge. I spoke to the people in the courtroom, but they gave me regional counsel. Is there any way I can get pretrial on this, sir? Because I'll make my court dates.
Sir, I'm going to decline that, but you are scheduled for 8:30 tomorrow morning in the division which the case is held. And
okay, thank you very much.
Hold on a second.
Thank you.
So bond is $100 count one, 1,000 count two, and no bond on 18-0135-18.
What is this charge? I thought there was only one charge.
There's a municipal ordinance violation, there is a misdemeanor, and then the felony, which is the no bond. The felony will come up tomorrow morning, sir.
Thank you, Brother.
Okay, how'd your heart surgery go?
Good, it was angioplasty.
You doing okay? You look good. You look like you have good color and everything. I'm not giving you a medical diagnosis here, but...
Thank you. I had 2 stents in put in a couple of years ago.
Sign on the yellow line.
Well, enjoy and just relax until you get to court tomorrow, okay?
Thank you, Your Honor.
Have a good day. George Michella?
Judge, I've been informed he bonded.
Bonded, thank you. Tyler Hubbard?
He's here approaching, Judge, I mean.
Good morning, Mr. Hubbard. You have a new substantive charge for grand theft. I do find probable cause. State priors?
1 moment, Judge.
Judge, nothing to add by the defense. Mr. Hubbard gave me the phone number of his family. I intend on calling them after court to post his bond.
I'm showing no criminal history.
State care to be heard on any other matters?
Yes, Your Honor. Considering the amount of money that was allegedly taken, and that it was also a cash amount taken, I'm asking for a bond increase to $10,000.
Defense care to be heard?
Judge, considering his lack of any criminal prior, there is a presumption to be released on non-monetary conditions. After speaking with Mr. Hubbard, he believes that his mom, Maria, can't afford to post a bond. That's why I'm not asking for the court to take any action on anything and leave the standard bond in place.
Okay. Thank you to respective counsel. The court does believe a bond, the suggested bond is inadequate to assure the appearance of the defendants. The allegation is $21,000 in cash. $21,993.48. Bond is set at $10,000. Have a good day, sir. Okay. Eric McKinney?
Mr. McKinney is approaching, Judge.
Good morning, Mr. McKinney. You have a charge of possession of cannabis and grand theft. I do find probable cause as to each. Bond is set at $100 count one, 1,000 count five. Have a good day, sir.
Judge, can we see if his bond's been posted?
Yes, sir, give us a moment.
Thank you.
Has not yet been posted.
I'll call your mom right after court, sir.
Have a good day, sir. Brandon Ellis.
Mr. Ellis, come on up, please.
Mr. Ellis, you're charged with two new substantive charges, carrying a concealed firearm and possession of Xanax. I do find probable cause as to each. Bond is set at $1,000 as to each count. Have a good day, sir. Christian McDaniel.
Mr. McDaniel, come on up, please.
Mr. McDaniel, you're charged with possession of cannabis. I do find probable cause. Do we have any priors from Mr. McDaniels?
2016 grand theft, Judge.
Judge, considering his lack of any significant contact with the criminal justice system, and this is a cannabis offense, Judge, would the court consider releasing Mr. McDaniel on standard pretrial release? I don't know if the state has an objection to that.
Based on the nature of the offense, I don't have an objection to that.
Okay. Pretrial, any objections?
Perfect.
Mr. McDaniel, do you agree to abide by the terms and conditions of pretrial release?
Yes, Your Honor.
I do accept the recommendation of Mr. Romero without objection by the state. Pretrial release is so ordered. Have a good day, sir.
Sure. Thanks. As soon as you get out today, you have to report Thursday. Okay, good luck. Okay, thanks. Mr. Darby?
Mr. Romero, hold on one second. Can I get that last one back?
Typically, the felony case is bifurcated from the MO. I'm going to ask him to be placed on pretrial just on count one, and count two is no charge.
Okay, so count two is no charge. I don't need to set an ROR on that. That will not hold him in.
No, you can just leave it as is.
Okay.
Count one is the felony count, if we're going to put him on pretrial on that.
Yes, ma'am. Thank you for the clarification. Thank you, Mr. Romero. Demetrius Darby.
Mr. Darby, come on up, please. He's here, President Maine.
Mr. Darby, you have a new substantive charge for possession of cocaine, possession of cannabis, and driving while license suspended, third or subsequent offense. I do find probable cause as to each count. Is there any priors from Mr. Darby?
2016 felony possession of cannabis, 2016 possession of cocaine, delivery of oxycodone, 2011. Prior to that, looks like just misdemeanor possessions of cannabis.
Thank you, Mr. Linder. Bond will be set at 1,000 count one, 100 count two, $750 count three. Have a good day, Mr. Darby.
Judge, he's just asking if confinement status can check to see if his bond's been posted.
Not at this time, sir.
I'll call your mother right after court, sir.
Jonathan Brewington?
Mr. Brewington, come on up, please.
Mr. Brewington, you have a new you have a KPS for burglary structure. Armed. I do find probable. This is not armed, correct?
Yeah, Your Honor, that was booked in error. I reviewed the information this morning, and I would direct the court's attention to the not in custody KPS prepared by the clerk's office. He was charged by the state with burglary of a structure, which is a bondable offense.
Okay. State have a recommendation as to bond amount?
I do, Your Honor.
Yes, sir.
I'm going to be requesting a $15,000 bond, pretrial release of the GPS. Your Honor, this is based on not only the allegations in this case, but Mr. Brewington's criminal history. Theft 2016, resisting without violence, criminal mischief 2015. 2011, burglary of a structure, 3 separate cases, 43-month state prison. 2001, attempted murder, first degree. Attempted robbery with a firearm or deadly weapon, 76-month state prison. Those are the most significant priors, Judge.
So you're requesting what bond amount?
I'm sorry, $15,000.
$15,000?
Yes, and pretrial release with a GPS monitor.
Defense care to be heard?
Yes, Judge. My understanding. First, when was the alleged date of incident on this case?
September 4th, 2015.
Judge, this case is about 4 years old, if my math is correct. Right now, Mr. Burlington is working. He does odd jobs like paint jobs whenever he can manage to get clients. On a good week, he can make upwards of about $300 per week. He lives in Lauderhill with his grandmother. His grandmother's elderly. She gets Social Security. That's the only person that's going to be able to afford to post any sort of monetary bond. But from what Mr. Brewington advised me, he doesn't think his grandmother can afford anything. Now, his grandmother counts on Mr. Brewington to help around the house because of her age, Judge. So we're going to be asking the court, considering, I believe from what the state read off, his last contact with the criminal justice system was in 2016. This is a 2015 case. I'm going to be asking for Mr. Brewington to be released on pretrial release, Judge.
In consideration of the information before the court finds the state's recommendation of bond in the amount of $15,000 to be reasonable, electronic monitor. Have a good day, sir. Okay, Mark Alaya.
Mr. Alaya is here present, Judge. He advises he has private counsel, Mr. Ed Cohn. Mr. Alaya. We're talking about you, sir. Come on up. He's approaching, Judge.
Good morning, Mr. Alaya. You have private counsel?
Yes, sir.
Okay. You have 5 new substantive charges: possession of fentanyl, possession of Xanax, possession of orphine, cannabis, and paraphernalia. I find probable cause as to each count. Bond is set at 1,000 counts 1, 2, and 3 each, and 100 counts 4 and 5 each. Have a good day, sir. Jacob Johnson.
Yes, prescribed.
Yes, sir.
He's approaching, Judge.
Mr. Johnson, you have a charge of possession of fentanyl. I do find probable cause. State priors?
One moment, Your Honor. I'm showing that Mr. Johnson was arrested January 9th of this year. That was on a charge of possession of MDMA and possession of codeine.
Thank you, sir. Bond will be set at $1,000. Have a good day, sir. Okay, Steven Cooper.
It hasn't been filed. Got it.
Mr. Cooper's here, President Main, Judge.
Good morning, Mr. Cooper. You have new substantive.
Morning, sir.
You have new substantive charges: possession with intent for MDMA, resisting an officer without violence, trespass, and tampering with evidence. I do find probable cause as to each count. Bond is set at $2,500 count 1, 100 count 2, 25 count 3, and 1,000 count 4. Have a good day, sir. Arthur Crease.
Mr. Crease is approaching, Judge.
Mr. Crease, you have new substantive charge of possession of THC. State any priors?
One moment. I don't have him on my list. I know he has nothing locally. Does pretrial have any?
We're showing an address, permanent address of Cape Canaveral.
Yeah, that's why we.
That's right. That's Brevard County, Judge.
It appears that Mr. Crease is wanted out of the state of Georgia for failing to appear. I'm looking to tell the court what the underlying charge was that he failed to appear. While I'm looking at that, I see a DUI in New York State. From Georgia, it is a theft by deception. He failed to appear on that, Your Honor. Warrant is out.
Mr. Romero, pretrial is indicating there's a warrant out of Georgia for theft. Bond will be set at $1,000. Have a good day, sir. Okay. Rafael Candido Villela.
Medical reset, Your Honor.
Medical reset. Dermel Grahe.
He's also on loan. Medical.
Medical. Jose Gonzalez Olgun.
He is also medical loan.
Medical reset. Eugene Lumsden.
He should
Yes, sir.
Good morning, Mr. Lumsden. You have a warrant for possession of a weapon by a convicted felon. I do find probable cause.
Your Honor, this is a technical change of charge. As you can see on the booking, when he was first arrested, he was charged with possession of firearm or ammunition by convicted Florida felon. The state has filed a formal charge for possession of weapon or ammunition by convicted U.S. felon. His bond, since it is a technical change of charge, I'm asking the court to keep the bond that was originally set in place, which is $1,000. In addition to that, he has $7,500 worth of bond on other charges and a no bond parole hold.
In light of the no bond holds, Judge, for the violation of parole, we would not object to the court setting the bond as requested by the state.
Okay. Bond will be set on this count at $1,000. Have a good day, Mr. Lumsden. Anything else by the state?
Nothing from me, Judge.
By Mr. Reedy?
Yes, Judge, I'd ask you to sign these two orders allowing our office to go into the jail and photograph a couple of folks.
State, any objection?
None.
Anything by Mr. Romero?
I think he's gone.
I think he's gone.
He takes
Madam
off.
Clerk, anything?
No, I never take off, Judge. I'm here till the bitter end.
Anything else, Mr. Romero?
No, I'm just contacting my colleague to make sure that he got the information from Ms. Lender to give it to
For
the
the
clerk,
1
so
o'clock.
hopefully we can get the court files
Okay,
for
thank
this
you.
afternoon.
Thank you, Mr. Romero, for your assistance. Madam Clerk, anything else for this morning? Pretrial? BSO? Okay, we are adjourned until 1 o'clock. Have a good day, everyone.